the case has been disposed of. He has not heard the argument. My counsel has not opened his mouth. Judge has dismissed. So, if this will happen, then we are all, every lawyer will stand united and fight with that system. We try to fight the system of permanent lok adalat. Then we got the desired result. So, from that angle, let us discuss, because at this moment, we are on the issues at international level. So, we are, because these things, our internal, if any problem, we are discussing at different levels, it can be pointed out within internal this thing, because we will not have the opportunity of the advice, guidance, the views of the leaders from other countries. So, Dr. Ambassador Galal, I will request what you think about what is the feeling of the Gulf countries. Okay. Yeah.
Thank you, Mr. Chairman. I cannot say about the Gulf countries, but let me talk about Egypt. Yes. Though I am not a lawyer, but I have a fairly good knowledge about what is going on between the bench and the bar. For the bench in Egypt, they are less independent than the bar. And I must say, to the credit of the Egyptian Bar Association, they were fighting for more independency for the judicial system. Legally, the judicial system in Egypt is independent, but practically is not independent in one or two aspects, which both fought for it, and luckily in the last year they got it. One aspect, I don't know the experience of every country, but I'm talking about Egypt, that they have their budget allocated by the government and assigned on different items of the budget. So the fight was they should have the budget as just one figure, and the judiciary system will be entitled to allocate internally. Because if the government or the Ministry of Justice allocated it, then they can manipulate things as they like. And that was one of the independence which they got. The second independence which they got is to strengthen what we call the bar, the Justice Club. The Justice Club is originally a social, but is gaining more and more independence to discuss the professional aspect of the judiciary system. And they took recently, in the last 2 or 3 years, very tough position against the government, against the Ministry of Justice, and against the quote-unquote the pro-government judges. And they were very vocal on that matter. And luckily they get more leverage in this. For the Bar Association, as I said in the beginning, they are more independent, and even they elect people who are totally opposing the government from the political point of view or the system. And they have not only the right, they have no complaint or constraint for the judicial system. They have good cooperation. Everyone is independent and everyone is doing his role. But they are entitled to plead a case for their client and also to plead a case for the general public, for certain grievances or certain things against the general public, which has no case for a personal individual person, but the Bar Association or any of the lawyers, they can say that this is so and so and so against the normal ethics of society or against the normal interests of the people or something like this. This is one thing. As the issues raised by Mr. Agrawal about the foreign lawyers taking cases in Egypt, they are not, to the best of my knowledge, they cannot do it except through an Egyptian lawyer. So they can cooperate, but the one who appear in the court should be an Egyptian lawyer. And this particularly in the law firm which they do the investment or commercial transactions and things like this. And they are manned by the Egyptians, but the foreigners, they can have a name of a law firm. For example, we have McKinsey law firm, which is a foreign company. We have others, but they are manned by Egyptian lawyers per se. So I fully support the argument, very good argument by Mr. Agrawal about the Indian lawyers to be exclusively the main lawyers in front of the courts, the Indian courts. This, for the reasons he has mentioned, and we support this argument because our people, we have plenty of people, Nigeria, Egypt, India, Pakistan, Bangladesh, we have so many talents. And psychologically, because we had been part of the British colonialism and imperialism, so you find the human being is human being, so they find the judge will incline to the foreigners, as the saying, the other side of the fence is greener, so then they will be against the interest of our people. So that is one thing, but the other side of the coin also that our people should be allowed to, if we want, should be allowed to have the same treatment in developed countries. And as there are many restrictions, particularly the visa, and nowadays with the terrorist quote-unquote terrorist phenomena, then our people, they cannot go to these countries even as a tourist. It is very difficult. So they will lose the cases, they will lose their livelihood, and that has no offense to our European or American or Australian friends, but it is normal. Every country would like to maintain the livelihood of its own people first, and then charity starts at home, as they say. Thank you, Mr. Chairman.
Thank you, Dr. Ambassador Galal. I welcome the Acting Chief Justice of Patna High Court to this session. I also welcome the President of Allahabad High Court Advocate Association, Mr. P.P. Srivastava, to this meeting, and other distinguished judges from Patna High Court, Rajasthan High Court, this UP Court. And now I will request Justice Namuddin, who has been the judge of the Bangladesh Supreme Court, who has been the member of the Law Commission, member of the Election Commission of Bangladesh, to enlighten us, and thereafter we will request Mr. Bilal to tell about Bangladesh aspect. You can come here only.
Thank you, Mr. Chairman. Mr. Chairman, the learned panelists sitting with me, ladies and gentlemen. I have been asked to speak about the conditions prevailing in Bangladesh. Actually, the subject Initially, I did not understand the meaning of the subject, Bar Leaders Conclave. So I asked my friend sitting on my left, he is now not here, there, what is the meaning of conclave? So he also could not answer this question. I then asked Mr. Agarwal, what is the meaning of conclave? He said, conclave means conclusion.
No, 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 no. I told when you will see, then you will understand what it is.
So in
Because
fact,
meaning, you see, when you are going to do practically, there is no need of asking the meaning.
so, in fact,
Why to waste time on that?
functions, gentlemen, ladies and gentlemen, the functions of the lawyers, the duties of the lawyers never ends. It continues perpetually till he breathes his last. In fact, the relationship between the bar and the bench was previously absolutely balanced, and they were unanimous in all respects to safeguard the interest of the bar, members of the bar. And so far as the bench is concerned, they stood, unitedly they stood as one man by the bench. In this connection, I will tell you only one episode. When Justice Shahabuddin Ahmed was the Chief Justice, subsequently he became the President of the country, some appointments were made to the Supreme Court bench without consulting him. Although in the Constitution, present Constitution, not in the original Constitution adopted in 1972, but in the present Constitution, there is no provision for to consult the Chief Justice before appointment of the judges of the Supreme Court. But although there is no constitutional provision, the long-standing tradition of consulting the Chief Justice was being followed. In this particular case, the Chief Justice was not consulted, and certain appointments were made. So Chief Justice did not try appointment of 2-3 persons because of their integrity was questionable. So he said that I cannot accept this appointment, and he called a meeting of the members of the bench. All of us attended, and he sought our opinion. So I said that, sir, you do one thing, don't administer oath to any of them. So he said, it is my constitutional obligation to administer oath. Should I violate the Constitution? Go and think again and then answer. So after the following day I went to him and I told him, that, sir, you don't refuse to administer oath, you just postpone the date of administering oath, sine die. So there is no violation of the Constitution. He postponed the date of administering oath. In the meantime, the bar stood as one man, and the bar adopted a resolution that they would boycott the courts of these judges if they are appointed. The government was ultimately compelled to rescind their appointment and then consulted the Chief Justice, and after consultation with the Chief Justice, the appointments were made. But of late, say in recent times, because of politicization in the bar, executive control on the members of the bar has been complete. And now, at the present moment, there is a clear division between 2-3 sections of the bar. They are not unanimous on any point. 2-3 divisions are clear divisions. And this is the result of politicization